So I have an update for you all on the rare breed trigger lawsuit against the ATF. And the update is that the case has been thrown out. So let's talk about this. But real quick before we jump into this video, if you think that the ATF needs to be abolished, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the supporters of the channel, which is Safe Life Defense. Safe Life Defense has some of my favorite soft body armor out on the market. I actually keep one of their vests in my car just in case. So if you're in the market for something like that, I highly recommend Safe Life Defense. I'll leave a link to them down in the details section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, some news broke today that the rare breed trigger lawsuit against the ATF has been dismissed by that Florida court. For those of you who do not know what's going on in this case, what happened is that the ATF sent a cease and desist letter to rare breed triggers back in about July. In the letter, the ATF claimed that in their eyes, the rare breed FRT-15 force reset trigger meets the definition of a machine gun under the NFA and the GCA. Because of this, the ATF claimed that these triggers by rare breed were subject to registration, taxation, possession restrictions like actual machine guns are under the GCA and the NFA. Also, the ATF claimed that the possession of these triggers outside of those restrictions in the GCA and the NFA would subject potentially people to criminal penalties and fines as well, because they would be in illegal possession of machine guns. Because again, the ATF is considering these triggers to be machine guns. Actually, to be clear, what they're claiming is that the trigger is a combination of parts designed and intended for use in converting a machine gun or a weapon into a machine gun. Therefore, the trigger itself actually is a machine gun. So they're claiming, since it's a combination of parts that could be used to create a machine gun, the trigger itself is a machine gun. So I understand that's some weird workaround, but that's the ATF for you. Again, interpreting a definition to make things fall within that definition of a machine gun, something that was never intended to be included in that definition. But just like we've seen with other things like the pistol brace issue, like the frames and receiver issue that the ATF has proposed some rules on. Once again, the ATF is interpreting things to make things fall within broader definitions so that they can go in and regulate them. In the letter, the ATF told rare breed triggers to cease and desist the manufacture and transfer of those triggers to people, and to also contact the ATF so that they both could figure out what they should do with those triggers that were already sold and transferred into the possession of law-abiding individuals. Well, in response to that, Rare Breed essentially told the ATF to kick rocks and filed a lawsuit in Florida. In that lawsuit, Rare Breed sought a TRO, which was denied, which is a temporary restraining order. They sought that against the ATF, the court denied it, and then they sought a preliminary injunction, which I made a video on, which was also denied by the court. Well, now we got news that the court has dismissed the case altogether. So let me read the order that was issued by the court, since it's only a couple paragraphs, so you guys understand exactly what the court is saying in their dismissal. So this is the order. It states, this cause is before the court upon sua sponte, which is a Latin word for essentially on the court's own review. There wasn't a motion to review this issue, but they say upon sua sponte review of the file. On August 3rd, 2021, this court entered an initial order, which reminds the parties of their obligations under Local Rule 3.02. That rule states that within 40 days after any defendant appears in an action originating in this court, or 40 days after the docketing of an action removed or transferred to this court, the parties must file a case management report. The parties were also warned that failure to comply with any local rules or court orders may result in the imposition of sanctions, including, but not limited to, the dismissal of this action without further notice. The parties have failed to file a case management report, and the time to do so has passed. Therefore, it is ordered and adjudged that this case is dismissed without prejudice. So that's the court's order, and essentially the case that was filed has now been thrown out. But that doesn't mean that Rare Breed has lost, or it doesn't mean that they've won. And essentially, right now, the issue isn't over, and there is still opportunity to once again file the case. But if you hear anyone saying that the ATF won and that this case is over, that's not correct. The court did not issue an order ruling on the merits of this case. They didn't rule in one direction or the other. Essentially, they just dismissed this case because the parties failed to file that case management report. A case dismissed without prejudice means the case is done, but there's still the ability to refile a new case. Often this is done to correct errors in a case, errors or issues in the filing, or for the parties to gather more information if the case just isn't ready actually for the filing. Here, however, the case was dismissed because the parties did not file that case management report, like I mentioned. And essentially, that looks like it's just a standard form outlining things like discovery deadlines, mediation dates, and other pre-litigation requirements. So per the court's rules, the parties have to do that report by a certain date. These parties failed to do that. They were warned that if they did not file that form or do that report by a certain date, the court could dismiss this case. They didn't do it, and so the case was dismissed, but without prejudice. And like I said, the case was dismissed without prejudice, which is in contrast to a case dismissed with prejudice. If a case is dismissed with prejudice, that is not good. And if that was the case here, that would be really bad for Rare Breed because that means that they could not refile their case. But that isn't what happened here. So essentially, Rare Breed has the ability to and likely will refile the case against the ATF with a finer tuned argument section with more evidence. And so just expect that this case will repop up. But as of right now, so with the dismissal, it's pretty much back to square one. And again, expect for the case to be refiled. In the meantime, I want you guys to keep in mind that the ATF's stance remains pretty much the same that has been this whole time, that they are considering these triggers to be machine guns. However, Rare Breed has made multiple statements that they will not stop making or selling these items until they actually get a court order, and a court order that says that these are indeed machine guns based on the definition of the NFA and the GCEA. And again, this order by the court, this dismissal, did not rule on the merits of the case. They didn't rule one way or another. So there's not actually a court order saying that, yes, these triggers are indeed machine guns as defined under the NFA and the GCEA. They just kicked this case, and it's just taking everything back to square one. So the main takeaway from this is that this isn't really good or bad. It's more neutral. If it were to lean any one way, it may be more bad, but kind of just more frustrating because the case will need to be restarted back at square one. They will have to refile to start the case again. But as of right now, it's not necessarily a good thing, not necessarily a bad thing. The court hasn't ordered a ruling on the merits of the case. Essentially just the case is off the docket and it's gonna have to be restarted. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos, in this type of 2A news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, impacting this channel, and helping these videos to reach and educate more people. So one of my goals was to reach 200,000 subscribers by the end of the year. And because of you guys, it looks like that's definitely going to happen. So thank you so much for that. If you're not subscribed, just go ahead and subscribe. I would greatly appreciate that. And if you're a new subscriber, comment down below that you're a new subscriber and I'll make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget that Snatch was built by arm scholars and Snatch will be maintained by arm scholars.